All right. Do we need a public defender's office or the equivalent of in family court?
I mean, philosophically, I don't know what's different in regular civil family court than other cases where you are entitled to counsel, such as the dependency, neglect, and abuse docket, which is not criminal, but by statute, because your parental rights are at stake, they make provisions for court-appointed attorneys. And whether it's, I mean, they don't use a public defender, independent attorneys. They use, each division has a list of attorneys that take appointments in that case.
Yeah.
And I know there's actually, our previous governor made a big deal out of that and wanted attorneys that were not within that division on some of those cases, but also wanted that to be controlled by the cabinet, which I think is problematic in and of itself. But yeah, this has been something that's going on. I just don't know why, if a judge can take custody of your child, or, you know, as we see, even if they don't take custody, they can restrict you from having any contact with your child, and they can do it over virtually nothing, as we saw in, and you know, the Court of Appeals found that Judge Ogden failed to find any reason under the law why she restricted a father from seeing his kids, why you shouldn't be afforded an attorney to protect your rights.
The test should be whether or not that there's a fundamental constitutionally protected right that's in danger. And your right to parent is a fundamentally protected constitutional right.
Yep.
And, you know, Gideon, when Gideon happened, which is the Supreme Court case that allowed, or that created essentially the public defender's office, or the requirement that you were entitled to counsel if you were charged with a crime, it's because the system had got cocky, you know what I mean? And they were treating pro se people like shit. And I will tell you that you see that so much in family court.
It is true.
It's the way, first off, the way that these judges speak to pro se people would literally shock y'all if you see it. And we're going to start posting.
Some of them.
Yes.
Again,
Oh, of course.
Some of them are, I mean, we've given credit to judges. We've sat in a motion hour and talked about how good people were dealing with pro se stuff and explaining the process and things like that. So,
and explaining the process, explaining the court's process, because there's also, you have to think at this from every different angle. The judge has to comply with the judge's ethics. And ethically speaking, a judge cannot give legal advice.
No, absolutely not.
So then you have the dichotomy where they're explaining things, they're explaining how they handle their docket, and then you have a person whose constitutionally protected rights is being affected or may be affected, you know, probably taking that to some degree as legal advice, when the reality is there could be so many other legal options for that person that they're unaware of.
Yeah, I mean, most of what I was referring to that we've noticed was really how we've seen some judges conduct motion hour and explain that why they're calling attorneys' cases first. They're not doing that because the pro se ones aren't important, but sometimes they need more help, or not more help, but more time, because they don't have an attorney there to argue it, and that the attorneys have to get to, like, that kind of stuff that's not legal advice. Now, I know exactly what you're talking about. I've had so many cases, which was especially true on the domestic violence docket, where you have a pro se person bringing the petition, and the judges will really step way over into giving legal advice,
100%.
and telling them what to do, or arguing with them if they come in and say, this is what I would like to do, trying to dissuade them from doing it.
And let's step back. Earlier, you said, so our dependency, neglect, and abuse docket, you are entitled to an attorney. And you mentioned earlier that there's been some political drama as far as how this list is created. But like, let's take a step back. I don't believe the cabinet should be in charge of picking the attorneys to represent, but I sure as shit don't think that the judges should be in charge of the attorneys that appear before them, because that's advantageous for the judge to pick somebody that's just not going to give them any problems.
Yeah, and I don't know that that's really what's happening, or like that was the motivation for picking, but it just forms the system where it's just the cases tend to get treated the same way, and it's just this whole, I don't know.
These attorneys on the dependency, neglect, and abuse docket, and this docket requires 1 day of work a week. Obviously, if there are trials, they may be scheduled on another day. And this can be things that would cause you to literally lose your child, right?
Oh, yeah. I mean, and then they see some of the worst stuff. I mean, some of the stuff that there's people that should never be in the system whatsoever, but then the really, really bad stuff goes through the same system.
100%.
The worst kinds of abuse and physical injury and neglect and things like
and
that.
let me be crystal clear. When I say there are people that deserve to lose their children, there are people that deserve to lose access to their children. There are people that deserve to have their fundamentally protected constitutional right restricted, just like there are people that deserve to be incarcerated. That being said, it's the Constitution. You've got to comply with those rights and treat them. This is the United States of America.
Yes.
But the problem with the judges picking their attorneys, it would be like if you were charged with a crime and you were appearing before the judge and you couldn't afford an attorney, would you want the attorney to pick the person that was appointed to represent you, question the system, the attorney that goes out to lunch with the judge, the attorney that has access to the back? Or would you want an independent body that's going to stand up for your rights?
No, I agree with that. I think coming in, I mean, I've represented enough people who started off, they were either third-party caretakers who aren't entitled under our statutes in dependency, neglect, and abuse cases to have an attorney, or have been working with a court-appointed attorney and decided they needed to save up and pay for a private attorney because of their impression of how the system was working and how it was don't rock the boat, and the person that was appointed was not really protecting them all that well and was just sort of playing nice with everyone and not listening to them. And I mean, I think there's definitely, it was always my perception when I went in as a private attorney in there that there's a collective groan that, oh no, the people might actually do discovery and they might actually make us do things or remember the names of the kids we're talking about or something like that. And it's so absolutely, if I were for some reason put in the place where my kids were in that system, I would absolutely want somebody that's independent and outside of that system.
And the other thing, just the way that these judges in Jefferson County in particular handle their dependency, neglect, and abuse docket, a private attorney is going to be exorbitant because there is no scheduled time for these hearings. So you're going to be there. You know, like, for example, the TikTok judge, you know, if her docket starts at 8:30, an attorney hypothetically could be there at 8:30. You know, she arrives 10:30. So that's already 2 billable hours. And then that case may not be called till 3 p.m.
Yeah, that's right. I've appeared on a morning docket, maybe not 8:30, like the 9 o'clock, you're supposed to be there. And I've waited through lunch to come back in the afternoon before the case is called, even on something routine, just because it's a packed docket. And you know, it was very expensive for my clients. And they know when someone was hiring me on one of those cases, I was very blunt that these things involve tons of standing around, sitting around. And they're the kind of things that every now and then there was something routine. You could appear remotely. But I would always tell my clients, you don't want me to do that because everyone else is standing around waiting and they're all talking about the case. And you're not involved in those communications if you're remote. You can be, but I have been completely left out of those enough times to where they would decide what to do. And then, I would call someone's cell phone and say, hey, is this case ever going to be called? Oh, yeah. Sorry, we forgot to tell you this is what we decided to do. And I'm like, you don't get to decide what to do on a case where my client has a say in what's going on.
And not even that, decide. You don't have the right to speak about the case with another attorney without me participating in the conversation, right?
No, that's right.
Ex
Or
parte.
go in front of the judge and put something, oftentimes they will write something up, put it before the judge. The judge will just read it into the record and there won't be any formal proceeding.
Called a reading.
Do that with half the people there or less.
Yeah.
And so I agree. I mean, it seems like, and I know that there was a big push to have a change to the way the system works with the court-appointed attorneys, and I was not in disagreement with that. But doing it through the cabinet made no sense because the cabinet is an adverse party to a lot of these people because the cabinet will take custody of a child, and the parents are effectively, from a legal standpoint, trying to win custody back from the cabinet. So if the state has an interest in the custody of the kids and they're going to actually hire the attorney that...
It's insane.
Yeah, that made no sense. And I think that's why that whole idea died, but it leaves us with a system that isn't working very well. But at least in that system, there are attorneys representing most interests. Now, again, temporary custodians, people that actually have legal custody of a child, they're granted legal custody of a child in these cases. They have a legal right at that point.
Right.
And they have no right to an attorney even within that system. But in the private cases, normal divorces, custody actions, there's no right whatsoever.
Well, and then just really quick on the dependency, neglect, and abuse docket, I wonder, because these attorneys are making $500 a pop, but just from a cost standpoint, as much of the dependency, neglect, and abuse, like having a public defender that was salaried, that's completely independent, it may be more cost effective. And then to transfer over to just your normal circuit court, which is custody or divorce actions. Legal aid can't handle many cases. Legal aid does a hell of a job for the most part. And
oh yeah, but they can't handle the types of cases they take on because they don't have the resources.
No, they're not funded for that. Like, they're not in any capacity to handle people that can't afford an attorney.
Man, they do a hell of a job. I mean, the mediations and different things that they do to keep people from having to go through the system, they save a lot of trouble for people, but they can't ask them to take on this whole other thing
unless they're properly funded, like the public defender's office.
That's right.
But I do think that, it's something that would probably drive some of the cost down. It would regulate the market, because people should not be paying. And I want to be clear on this. Y'all need to understand that if you have a contentious divorce with children involving, custodial evaluations, parenting coordinators, FOCs, GALs, blah, 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 what that costs over a 2 or 3 year period, most of the sitting judges on their salary could not afford.
No, that's true.
And
that's true. You would be mortgaging your house, cashing out your retirement, all kinds of things to afford that.
Yeah, cashing out Nana's retirement. You know what I mean?
My fees on a 2 to 3 year like custody battle would be multiple times the net salary of someone that's sitting on the bench, probably.
Yeah,
not probably, absolutely.
Yeah.
And that's just my fees, not the FOCs and the GALs and the custodial evaluators and the time off work and all of those things that are going on. So it is extremely expensive.
And also, I just think as a society, we have to decide what is important. And if protecting people's constitutionally rights to parent, isn't that, then what is? Because what people don't understand is that this could happen to you. You could lose your children literally without a mugshot.
Well, and, we're seeing people that have attorneys have their kids ripped away from them because the courts are just not following the law.
Yep.
But you have a much better chance of rectifying that if you have counsel and can stop what's happening.
Also, like the benefit of the public defender's office, when I worked there, we had a motion bank. We saw what was happening in counties throughout, and you would have conferences. You could share information, and you could see these problematic patterns. For example, we had a lot of problematic patterns in Lexington when I was a public defender's office with canines. Got some great case law on that to make sure that people were constitutionally right to not be, detained and seized and searched was upheld. Sorry, I lost my train of thought. But the importance, the importance of having an independent body that protects the people from the government, that is literally, that's the whole point, y'all. Is it not?
Yeah, it's one thing. I mean, like I said, philosophically, we're talking about fundamental rights. How do you make the distinction you're entitled to? I mean, I understand in Kentucky, at least, there's a statutory distinction. These type cases that are brought under this statute, where your kids are forcibly taken by the government, where the government is coming to take custody away for dependency, neglect, or abuse, you're entitled to an attorney. But how about when the government isn't a party that's trying to take it, but instead is sitting on the bench and is going to take your kids away and may not be paying any attention to due process or the Constitution? I think that you're going to continue to see those kinds of abuses unless you have everyone represented.
Absolutely.
You continue to see them for represented people. I mean, we find out on these cases, and so many of them, the problems that we see are cases that have attorneys.
Yeah.
So I can't imagine going in there, not being able to afford an attorney, and dealing with a system that you have to constantly kick and scream to make sure that you get a hearing, that people get sworn in, that the rules are actually followed. And if you don't know about those things, you're at such a disadvantage.
Well, there's also that accountability from having the public defender where you have colleagues, you have a boss, you have accountability. Like, for example, Adair versus Emberton. You have so many private attorneys waiving that under pressure from the FOCs, and from the judge. But now, if you had an employer and a policy within the public defender's office, obviously we're going to comply with the law. You can't ever waive Adair versus Emberton. It really actually does de-escalate the judge's frustration. It's like, oh, that's the policy of they're going to comply with the law. And so there's the insulation. What family court needs in particular, more than any other court of law that I have ever experienced or that's in this country, is it needs accountability. It needs checks and balances. It needs systems in place that protect everything, because you have to believe that one bad temporary order could change your life in perpetuity.
It certainly changes a child.
Yeah.
I mean, imagine you're at school one day and someone you haven't seen in a long time shows up and takes you across the country unannounced just because a judge didn't follow the law and issued a very bad temporary order. I mean, that's the kind of thing that will affect a child probably the rest of their life.
Without question.
That kind of trauma leaves a lasting scar.
Yep. And there's no mugshot for that violation of law just yet, anyway.
No. True.
But let's segue on our YouTube. There is a motion hour of Brian Gatewood. Brian Gatewood is notorious for speaking in a demeaning manner. Would you say? Would you agree?
Yeah. And, one of the things you showed me, you were appalled about this motion hour video because you had seen it happen and you were sort of embarrassed by it.
Totally.
And you went and got the video of it, and I thought, he's actually speaking to that pro se person nicer than he spoke to me. It doesn't mean it's less egregious, but I've had plenty of motion hours where he's talked to me in a worse way than that.
Oh, absolutely. He does not know how to speak to people. I mean, that goes without saying. But we'll put that up on our YouTube. But just essentially it talks about, first off, this pro se person does an extraordinary job of talking to the court.
I had to ask you, because you looked into the case, was that a pro se person? Was that an attorney maybe from out of town that doesn't
know our local rules?
Know all the you call them local rules. It's not even local rules they were arguing about. Each division seems to put out inconsistent and different rules about his or her motion hours that if you are a member of the public, and pro se members of the public are required to be held, they're required to play by the same standards as attorneys, and they're held to the same standards. And I understand that, but so let's say that I'm pro se, I'm appearing before a judge. I want to know what the rules are. I'm going to look at the rules of practice and procedure. I'm going to look at the family court rules of procedure and practice. I'm going to look at any statutes, and I'm going to look at the local rules for how the local court works. If I looked at all of those things and committed them to memory, I would never see the extra rules that these judges put in their courtrooms that are inconsistent.
Yeah. And just to be clear, so we're using the word rule. There are things in the law like terms of art where they mean something different in real life and then they do in a courtroom. But when we say rule, really the fact and backstory here, what the judges have started to do in Louisville is they release their pre-rulings for motion hour. And on the top of it, like if their motion hour starts at 1:30, it will be like, if you have any objection, you got to tell me by 10 a.m. But that's not adopted, to my knowledge, in the local rules of practice. That's not signed into order by the chief judge.
Well, and it's inconsistent. Like some judges say it just says before motion hour. Like it says like if it's a 9 a.m. motion hour, you got to make your objection before 9 a.m. Okay, that one is a little obvious. Like people, it's not out of the ordinary. But we have others that are, let's say, we have motion hour at 10:30. You have to let us know of your objection before 10 a.m. 1:30 p.m. You got to let us know before 10 a.m. And then one will be at 10:30, and you have to let them know before 10 a.m. So they're all different. It's
right.
I think almost every single one has a different amount of time before the motion hour starts that you have to let them know, and a different way to do it. Email this person, call this person, file something. They're all different, and there's no reason why anybody would be able to know that.
Right, and goes back to just fundamental notice. You have to give people notice of the rules. You know what I mean? You're not playing Uno with your Nana where things can just change on a whim. This is a court of law. You get a document that says the motion shall be heard at 1:30 p.m. on this day. You show up at 1:30 p.m., you're entitled to have your case called regardless of what you put on a website.
Yeah, in the case that you were referring to, the opposing counsel had filed a motion for additional time to respond to a motion that had been filed months before.
Yeah.
Like,
I did look up the court net on this, and it is ambiguous kind of how this came to be because this person was pro se. So in the sense of like not saying something that's not factually accurate,
got it.
I couldn't really ascertain completely.
Okay. Well, from the point of view of this person, he informs the court that he objects because he had filed his motion months before and there had been plenty of time to file a response. That was the argument that he made, so I was taking him at his word. But you're right. I have not looked through the file to see when this was filed, but according to him, months before. The judge is pretty condescending and nasty with him and doing it because, so he says, you had to let us know before this time that you had an objection. My pre-ruling was this was going to be signed. And he said, I did file an objection. So he had filed a response in the record objecting to it. And so...
And then the judge is like, well, that probably hadn't even made it up from the circuit clerk's office
Yeah, I haven't seen that.
Yeah.
I'll take a look at that.
I don't even have the file in front of me.
But it's like you're there to hear this motion.
Right.
I don't know why the judges don't know what the motions are that are in front of them.
Right.
First of all, what was he expecting that person to know? As a pro se person, he argued very well.
Mm-hmm.
He had filed a response in the record, in the case, saying that he objected to it, and then he showed up on time to make the argument just to be treated like basically you're wasting my time and your opposing counsel was here. We could have done this, but you didn't do the right thing. And it's like, it's impossible for pro se persons to know that there are different little pseudo rules that haven't been adopted as actual rules in each division that aren't put in the rules that you can actually look up and see. But there might be a website, and if you're lucky, then something's been published that says it at the top of it for a specific, I don't know. And I think to the extent that they make the rules very transparent, and if there's a pro se person on the case and you've communicated that rule very clearly to them, it would still be inexcusable to talk to them that way.
Exactly. Without question.
So those things all exist separately in my mind.
Yeah.
That this is bad and this is also bad. But even if none of this other stuff existed, why do you talk to somebody like that in your courtroom?
Who the fuck do you think you are? I mean, is what I would say. And again, that goes back to there's no way he would talk to somebody like that outside of court. I don't think. Maybe.
Yeah.
But
if he did, it would. Yeah, I don't think it would go well for him.
Exactly. And I was sitting there in real time that day, not watching that. I had just been there for the baby case, and that's why I stopped him on the way out. I'm like, what's your name, sir? He had no idea who I was because I was so just like, you cannot talk to people. It would be, and that's where family court's not reported on. But if a judge spoke to a pro se person charged with a crime, like still with the presumption of innocence in a courtroom like that, I think it would be viral all over TikTok.
I think it might actually. I mean, that might be something that the media would cover.
Oh, I know. Can you imagine? LOL.
Yeah. Well, I mean, I've seen that kind of thing when someone explodes or acts unprofessionally in a criminal court. It will make the rounds on the media. It won't get a lot of traction, but I would always see it because it would make the rounds with the attorneys. I don't know why this is any different. And I think that's an excellent point. If this happened in a different context, in a different court, it would be a completely different manner.
Yep. So, all right, well, submit your stories, judge-y.com. Remember, we're starting to post court proceedings from Louisville, Kentucky on our YouTube. Our YouTube is judge-y, and the handle is Judging the Judges. Thank y'all so much, and happy Monday.
See ya.
We need some justice. Content of this podcast is for informational and entertainment purposes only. It is not intended to be and should not be construed as legal advice. Engaging with this content does not create an attorney-client relationship between you and the hosts, guests, or their firms. The views and opinions expressed on this podcast are solely those of the individuals involved and do not necessarily reflect the official policy or position of any law firm, company, or organization. We make no representations or warranties regarding the accuracy, completeness, or applicability of the information presented. Any reliance on the information in this podcast is at your own risk. Laws are constantly changing, and every situation is unique. You should always seek the advice of a qualified attorney for your specific legal concerns.